Be seated, please. Welcome, everyone. On behalf of myself, Scott Brister, Scott Field, April Ferris, it's a pleasure to see such a crowd. First of all, we want to thank the University of Texas and Dean Chesney and his staff. They've been tremendous help and accommodation to a court that has no courtroom. We're working on that. Matter of fact, we met with some of the people in the governor's office this morning, but it's not going to happen anytime soon. Courtrooms just don't appear in downtown Austin very often, but so we are working on that. We've got 4 cases set on the docket this afternoon, and so we will be strictly enforcing the time limits so we don't get out of here. So we'll get out of here just in time for rush hour. So the first case, called Stephanie Muth in her official capacity as Commissioner of the Health and Human Services Commission versus Cook's Children's Health Plan. Who's present for appellant?
Corey Scanlon for appellant, Your Honor.
And you will be splitting time?
Yes, Your Honor.
Okay. So you all are responsible for splitting time. So if he takes too much of your time, that's on him, not me. Okay? Thank you. And appellees?
Your Honor, Warren Huang for the appellees, and with me are my colleagues Benjamin Grossman and Peter Walker.
Thank you. Mr. Scanlon, you may proceed.
Thank you, Mr. Chief Justice, and may it please the court. The Executive Commissioner of the Texas Health and Human Services Commission is statutorily delegated authority to procure contracts that provide best value to the agency in the areas of Medicaid and CHIP managed care. The trial court, at the urging of disappointed bidders whose incumbent contracts were set to expire, improperly enjoined the most recent iteration of that procurement, which caused the entire statewide procurement to halt, which allowed losing bidders to hijack federal Medicaid and CHIP dollars, and which caused uncertainty for millions of low-income Texans in their health care. That was error, because the disappointed bidders sued before allowing the statutory protest process to conclude, but more fundamentally, because every one of the disappointed bidders' claims is barred by sovereign immunity.
When should the suit have occurred if it was going to occur?
And I'm assuming that we're talking about an ultra-virus suit.
Yes.
In the contact procurement arena, there could be an opportunity for a suit for mandamus at the point that the request for proposals, which outlines how the procurement would go, is protested, and if it is clear that the commissioner is going to proceed with an illegal act, that would be the time to file a suit for mandamus. These bidders did not do that. They rolled the dice and decided, well...
So let me make sure I got that. Request for proposal is issued. I mean, they issue request for proposal, have a chance to or maybe comment before the RFP issues, then after the RFP issues, you have so much time, and you've got to file in that usually 30 or 60-day window.
So it's a little bit unclear. A mandamus action would only accrue if there was no adequate appellate remedy at that point. So if we're going to proceed with a procurement, the RFP demonstrates it's fundamentally flawed in some illegal way. Once they agree to move forward with it anyway, there's no mandamus action or ultra-virus action at that point. They would have to protest the appeal, and that's it. And I understand that that could be maybe counterintuitive to the court, that there wouldn't be an avenue for judicial review. But that is the balance that the legislature has struck with the Medicaid program. That's what you see in other procurements where immunity has been waived. County or municipal procurements have a specific statutory provision that say it can be enjoined. You don't have that here. So the legislature has not intended for there to be any judicial review. With the ultra-virus case, it becomes retrospective also at the point that the RFP has been locked in and the bidders proceed with the procurement. Because that's the opportunity to assert the illegality in the process.
So I like the idea of mandamus. The great thing about mandamus is you don't have to grant it all the time. You say, well, this is important, this one's not, this one's a close call, this one's a clear abuse of discretion. Ultra-virus, every case we get these days is an ultra-virus claim. If you don't have any ground, you just allege ultra-virus, and up you go to the 15th Court of Appeals. But now, may need to cabin this in a bit. Why would you not have an adequate remedy if the RFP bids aren't in? And could you tell from the RFP, I'm going to lose this bid, so I have suffered an injury?
That's the problem with the ultra-virus claim in this case. Ultra-virus claim, you have to establish that the state official exceeded, or they acted without authority. That claim, we've argued, is not right at this point because you still had the protest remedy. You had the protest appeal, which, again, there's two protests I want to make sure I'm clear about. You can protest the RFP. You can protest the notice of intent to award once the decision's been made who's going to get the award. And then there's an appeal to the commissioner. That appeal, the testimony is clear. It remains pending. Commissioner Young testified, I'm not going to sign the contracts until I'm able to decide the appeal. And I can't decide the appeal because I'm enjoined from taking any further action in the procurement now. So that was the fundamental problem with the ultra-virus claim here.
But isn't it true that, okay, let's just play that out. The decision's made by the commissioner, and at that point, if there's a claim made that the commissioner didn't follow the statute in this procurement, the defense by the commissioner is going to be, well, that's retrospective relief. We can't do that anymore because this is already done. Whereas the only chance you have for ultra-virus is you got to stop something from happening in the future. I mean, isn't that just as a practical matter what they were faced with here? Because you have to do something now or you lose it.
That's correct, Justice Field. And I want to kind of go back to what the question about ultra-virus was, I think, in Hall v. McRaven. They said that we cannot allow the ultra-virus exception to swallow sovereign immunity. And one of the fundamental fallacies that the other side has been arguing is that there's general jurisdiction to enjoin ultra-virus acts, and that is not how sovereign immunity works. The presumption here is that the state is immune from suit, and ultra-virus allows a very narrow remedy. And the case law in the procurement context has said it's retrospective if the contract has already been awarded. I'd cite the Utility Associates case for that, where they said it's not about when the contract gets signed that makes it retrospective. It's also asking to undo the decision by the city council to award the contract. And you have that here. That's very analogous to the agency making the decision of who is going to receive the award.
What do we do with the Wilson versus Community Health Choice case?
So the procurement was consistent with Wilson. That was a big issue on how mandatory contracts were going to be awarded under 533-004. Wilson said that the commission is not permitted to simply invoke a best value judgment to undo the provision in 533-04, which says you shall contract with a MCO that meets these certain criteria. None of these bidders meets those requirements, and they haven't asserted a 533-004 claim either. So this was consistent with Wilson. Wilson also says there was a possibility of prospective relief there because there was only one bidder that met the criteria, and you had a situation where the procurement had actually been canceled. So there was going to be another procurement. This procurement, by contrast, has been halted. It's been enjoined. And
Did the previous contracts lapse? Was there a drop-dead date on them, the expiration date?
I'm very glad you asked that, Mr. Chief Justice. These contracts are all set to expire, and this goes to their injury. And I want to talk a little bit about our standing.
Set to
on them.
expire when?
They were going to expire before the new contracts were going to go into place. I don't know the exact date, but
Would you let us know the exact date? Because this is not the first area of the law where if you can get a temporary injunction, you can keep something going forever.
The contracts have already expired. So
Okay.
right now they're getting these extension
We
contracts.
just have to extend it because we have no choice.
Yes, and that's another problem I can talk about. But if I may, I would go back to the standing argument. They've acknowledged that they're not asking for, they've claimed they're not asking for retrospective relief. They say that all the relief we're asking for is to halt the procurement. That's it. And the problem with that is the irreparable injury they've asserted, the possibility of business dissolution, the loss of their employees to poaching, which I fail to see how that's traceable to Commissioner. But anyway, we cited the Myers case that says if the injunctive relief is not going to redress the alleged injury, there's actually no standing. So they lack ripeness, they lack standing, and this is a retrospective form of relief. Turning to the TI itself.
Well, before you get there, I'm going to talk about ultravirus a little more because, frankly, the case law in this area is just a mess. And Houston Belt talks about statutes that provide absolute discretion. Are you claiming that this statutory scheme provided the commissioner absolute discretion?
It does provide absolute discretion to determine best value. So the statutory requirements that we are arguing about here today are all discussed in the request for proposal. There are 2 mentions to each of the statutory provisions, and the best value judgment is the main consideration. The provision says that the commissioner shall acquire goods or services by any procurement method approved by HHSC that provides the best value to the agency. Because of what happened in Wilson, where they said you can't just use best value to argue anything. Well, the agency took a very, very close look at that, and they said, here's what we're going to do. In this RFP, we're going to develop best value criteria that are going to explain how the commissioner is determining best value. And it developed 18 technical questions that fall under those best value criteria. That was the manner in which the commissioner exercised her absolute discretion to determine how to weigh these statutory factors. It was explained very well in the RFP to all of these bidders. So with that in mind, I want to kind of talk about the temporary injunction a little bit, and I want to flag tab 2 of the appellant's brief. That's where we've kind of put all the statutory language because this code has been redone non-substantively. So all the text is there to help with that. There are 13 bullet points in the TI. I don't have the time to go through all of them, but I'm happy to answer questions. But I want to talk about 2 of the main ones. One of the, I think, most egregious one was that the TI incorrectly stated that past performance was required to be considered. The statute says that the past performance may be considered. The exact language is that it may consider indicators of probable vendor performance under the contract, such as past vendor performance, the vendor's financial resources and ability to perform, the vendor's experience and responsibility, and the vendor's ability to provide reliable maintenance agreements. Again, may consider. And that's 1 of 11, and past performance is only a subset of that long list that I just read off. So the notion that they were required to consider past performance is just fundamentally wrong on the face of that temporary injunction order.
But getting back to the absolute discretion for a moment, do you agree, though, that there are some of those laundry list things that it was a shall? You shall do X, you shall do Y, you shall do Z. So how do we balance? Are you claiming that the statute that provides the absolute discretion is in conflict with that list? Or how do these go together?
I would assert that the way that it was harmonized in this case was that for instance, the preference, the shall give preference statutes. Now, a preference doesn't dictate the outcome. Ask any veteran who's applied for a federal job that they didn't get. The preferences say that can be, something that's weighed among all of these factors in the statutes. And they did that in the best value criteria. I can give an example on the quality initiatives point. Technical questions said that describe the respondent's quality improvement and performance valuation strategies. So it was solicited from these bidders. It was incumbent upon them to describe in their response how they would win that preference. So all of the best value criteria, I think we exhausted the discussion of that in our brief about how that was implemented into the RFP. And then if you look at Mr. LaFawn's bench exhibits 4 and 5, that's going to show you the scores. How did they score those best value criteria? Everything was documented in accordance with the statute. There is absolutely no way to argue with a straight face that the commissioner went outside of her statutory authority to procure these contracts. Very quickly, actually, I see I'm almost out of time. I'll go ahead and let my friend come up.
Very wise. Thank you, Mr. Scanlon.
I had the same reaction and was about to ask a question and realized now it's just going to be Mr. LaFawn's now.
Well, you should feel free to ask it, Justice Field, of course. May it please the court, Jason LaFawn for Molina Healthcare of Texas. HHSC, on behalf of the state and acting in its proprietary capacity, desires to acquire services via contract from managed care organizations like Molina Healthcare of Texas. For 2 years and counting, appellees have been interfering with HHSC's effort in order to protect their incumbency as service providers under long expired contracts. Their justification is that HHSC is allegedly failing to follow instructions given by the legislature in how to choose whom to contract with. But it is the appellees who are ignoring the legislature's instruction and asking the courts to as well. The legislature has directed where procurement complaints are to be heard. They are to be heard in the agency protest process. There, as the legislature intended, complaints about violations of procurement statutes and regulations are determined by the agency, and if they're found, what the appropriate remedy is.
But don't we have a kind of a weird scenario here? Under 391.309, says a contract won't be awarded that is subject to a properly filed protest until HHSC files a written disposition. But the HHSC executive commissioner may waive this requirement if the commissioner determines that HHSC must award a contract without delay to protect the best interests of the state. Is there another provision like this?
Yes, Your Honor. In fact,
Okay.
that's required by law. So what the statute says, 2155.076A, is that the agency's rules have to match now the comptroller. When it was, back in 1997, it was the General Services and Purchasing Commission. And that type of rule has been in place at least since 1987, and it existed in 1997 when the legislature told agencies to follow those rules. But what is left out of the bench exhibit of the appellees is the provision that protests may be heard after awards, and that unlike an ultra vires claim, a protest may void a contract. The result of the protest is that you may void a contract. The protest process gives the appellees a far greater range of remedies than their ultra vires claim does. But what it doesn't get them is delay, which is what they have always wanted. Because we talked about the expiration of contracts. Every year, there's a bridge contract because there's no other way to do it. And so every year, HHSC is extorted into operating with partners in the state's largest program that it does not want.
So let's play that out, though. Let's say you decided to do the protest, go to the commissioner says no, then what?
Then, Your Honor, much like in Houston Belt, the plaintiff there exhausted remedies and then sued on an ultra vires claim. It does not mean that their ultra vires claim is going to be successful, and in fact, it may not be. And if that's true, then protesters, those desiring to contract with the government, have the same remedies as those who have contracted with the government. They have an administrative process, and failing that, they may petition the legislature for permission to sue. There's no problem with that because these are all legislatively created processes. There are no inherent rights here involved.
But as a practical matter, I mean, for anybody who's ever had to file a lawsuit against the government, you're then retrospective reliefs, you've got no ultra-virus, you've got sovereign immunity. I mean, isn't it? It's basically a dead letter at that point, isn't it?
That's correct, Your Honor. Just like anyone who contracts with the state, although this is because of the nature of this process. In Houston Belt, they were able to sue because there was ongoing enforcement. That is the usual case. Most ultra-virus claims will have that, or they'll have some violation of right, which we're also missing here. And when the legislature created the protest process, it knew and intended that the agency was going to be the ones looking at the procurement statutes and the procurement regulations and deciding whether or not they were violated, and if they were, what the consequence was. The appellees are asking the courts to do
Isn't this
that.
statute different, though, in terms of, I mean, we've seen, and I know you have in your old job, plenty of statutes that give exclusive jurisdiction and administrative remedy, and that's it. This doesn't look like those statutes. Can you
Well,
comment on that?
So I would ask Your Honor to consider the statutory history of the protest statute. It directed the agency to follow the rules of the Purchasing Commission. For a decade prior to that, the Purchasing Commission's rules said it is the Purchasing Commission that protests will only be about statutory and regulatory violations, that it's the director of the Purchasing Commission that looks and decides whether or not there is a violation and what the appropriate remedy is. If Your Honors look at the Regent Rule in Houston Belt, not Houston Belt, in Hall v. McRaven, we have an identical situation. The legislature intended that the agencies would be the ones interpreting these rules because these are instructions from the legislature to an agency, and as Inri Stetson explained, sometimes they are just that. They are instructions, and that's how the two communicate with each other, and there are many, many mechanisms within the executive branch and the legislative branch to address compliance with these rules. You can go back a few years, and people at HHSC lost their jobs because of things that happened during a procurement. There is real enforcement here. The legislature cares about it. The legislature had a hearing on this procurement right after it in the middle of the protest process. This is not something that slips under the radar. It has, the way HHSC has done it, it is proceeding exactly as it is supposed to. The appellees and the district court have never presented any cogent reason why HHSC lacks authority to at least finish the protest process, because there is none. They clearly have that authority, and if the appellees are out of luck after that with a claim, their complaint is with the legislature, not with HHSC.
Are you familiar with any cases that have said that you can't file an ultra-virus claim in court if an administrative proceeding is ongoing?
Yes, Your Honor. Aspire Ventures from this court last month said you may not file an ultra-virus claim when an agency has exclusive jurisdiction.
I was saying there's the key. I was waiting on it. Exclusive jurisdiction we'd have to find, correct?
Yes, and there is a pervasive regulatory scheme here, just like in Janet, and this is clearly within the scope. Thank you.
Thank you. Ms. Wong?
Good afternoon, Mr. Chief Justice. May it please the court. This appeal is about the Commissioner's unlawful attempt to obtain absolute and unreviewable authority to award up to $120 billion in Medicaid and CHIP contracts that will affect millions of Texas's most vulnerable women and children.
But you're not representing the vulnerable women and children. You're representing a big healthcare company, right?
Your Honor, our health plan includes over 500,000 of those women and children, so we are.
Of course it does, but you were not hired by those 500,000 people. You're here representing a big company. Now, my question for you is, do you have a right to a government contract?
No, Your Honor, we do not have a right.
Nobody
to a
does,
contract.
right?
Correct.
So what's the basis of your claim? Well, they didn't follow procedures, okay. But the other side is saying the deal, since you have no right, it's not like you've got I don't know what it would be, a substantive due process claim. You got to go through the administrative procedures, and you may win, you may lose, but I'm sorry, you've had this contract for a while and even extended it, and why should we keep extending it because you think they didn't consider this and that?
Your Honor, the claim that we're asserting in this case is the exact claim that the Supreme Court has repeatedly recognized over the years in the City of El Paso versus Heinrich case and the Houston Belt versus City of Houston case, and that is an ultra vires claim. And the Supreme Court has said that we are entitled to assert an ultra vires claim if the commissioner or any other government official acts outside the bounds of their authority, even if they're exercising some discretion in
So
this
how
case.
do you outside, I mean, we have this in 2 of our cases today. We've got a statute that says, well, before you do something, you need to consider this. Consider that. That one, Primex is in a private context, as a public. You need to consider this and consider that. How do we enforce that? I mean, do we have to ask the commissioner, did you think about this, or did somebody on your staff think about this? And all they have to say is, well, I thought about it, and the answer is no. How is that justiciable? How could we possibly enforce something that says, consider this before you decide?
So, Your Honor, the particular issue in this case was whether or not the commissioner complied with multiple statutory preferences and requirements that required her to consider or grant preferences with respect to various factors that go into awarding a contract in this case. We conducted a 4-day evidentiary hearing in the trial court on the plea to the jurisdiction as well as the application for a temporary injunction. And at that hearing, evidence was presented which was sufficient to create a fact issue to support a temporary injunction in denial of the plea to the jurisdiction, indicating that the commissioner did not, in fact, consider the statutory preferences and requirements
Did the commissioner concede that? She didn't consider it?
Your Honor, I believe that the commissioner, of course, vociferously opposed it, but
Which raises another problem. It was a different commissioner back then, right?
Right. Your Honor, it doesn't matter whether it's Commissioner Young or Commissioner Muth because
That's not an answer to my question. It's a different commissioner, right?
There's now a different commissioner, but she was sued in her official capacity.
And if this is not this is ultra vires rather than mandamus, but and normally, if it's a discretionary decision, we got to send it back to the new person and see if they're going to decide the same way.
In the mandamus context, yes, Your Honor, but not in an ultra vires claim here. As we mentioned before, she was sued in her official capacity, so it didn't matter whether or not the commissioner has changed over time or not. The bottom line is, at the time this suit was filed, the commissioner gave the testimony that she did, and the trial court based her decision on that testimony.
And
so,
just to be clear, you're saying she said, no, I didn't consider that.
Your Honor, her testimony from the Deputy Executive Commissioners, Kay Molina, as well as James Ramirez, they presented evidence that those factors weren't in fact considered. We also developed evidence that was presented that when the evaluators were trained to assess and evaluate and present and score these bid proposals, that they were not informed about the existence of these statutory preferences and requirements or told to consider them in awarding their scores.
What do we do with the argument that, past performance is kind of the water in which we're swimming, and so we don't need to have a blank that says, past performance, because past performance just, is somehow implicated in everything? What do we do with that?
So, Your Honor, if I understand your question, I think it's in connection with Mr. Scanlon's argument that past performance is a factor that may be considered, and why is it mandatory? And so if you'll look at Exhibit 1, oral argument Exhibit 1 that we provided the court, it lays out the relevant provisions of 2155.144 of the Texas Government Code. They are correct that the past performance factor is under 2155.144D, and that 2155.144D is a list of the factors that may be considered, relevant factors that may be considered. But here, at the evidentiary hearing, we developed evidence that the Deputy Executive Commissioner of the HHSC said that one of the relevant factors in a procurement is past performance. So as a result, if you turn to 2155.144C, it states that the commissioner shall document and consider any relevant factors it considered in the procurement. And since there's testimony that past performance was in fact a relevant factor, they were required to document that they considered it. And it's our position that, again, there's no evidence that past performance was in fact considered in scoring and deciding the procurement in this case.
And all we need here is a fact issue, is that
That's correct, Your Honor. It's all it takes in. The trial court issued findings based on more than ample evidence to support her rulings in this case.
So just to follow up on something I was asking earlier, I assume you don't agree that this is an absolute discretion situation, right?
Yes, Your Honor. Here, we believe that it's important to note that we're not quibbling over how just the different multiple statutory preferences and requirements were actually applied. Our argument is that those preferences and requirements weren't considered at all. And that's what distinguishes this case from cases like Hall versus McRaven.
And I'm still trying to hear what you're saying. Are you saying they weren't considered, or they didn't document that they considered them?
It's both, Your Honor. As to past performance, which requires documentation, there's no evidence we submit, or at least a fact issue, as to whether or not it's properly
As to the ones
documented.
that don't require that to be documented?
Yes, Your Honor. For example, with respect to the statutory preferences, where the commissioner was required to give a preference as to a particular factor, we submit that there's no evidence that that preference was actually accorded. And the way you determine that is by looking at
I'm sorry, was actually what?
was actually accorded, was given. The preference was given.
Accorded. Thank
Yes,
you.
Your Honor. And that's determined by looking at what the evaluators were trained to consider and do with these factors, as well as the scoring sheets, which indicate whether or not a preference was actually given or not. And we respectfully submit that there is no evidence, or again, at least a fact issue, that those preferences were not actually given or considered.
So back to the discretion piece. I know I keep beating this horse, but how many factors, does it matter how many factors were not complied with? For example, how do we, if there's not absolute discretion, and you go to this list of factors that they shall consider, but there's a documentation requirement, for example, and let's say that's the only thing that was missed. I'm kind of thinking in that situation we wouldn't set aside a huge procurement. How do we know? I think that underscores a problem for us with ultravirus. How do we know when there's enough? How do you know you've now ignored 10 things that they listed? You've now ignored 5 things, 15 things, 50 things. How do you know when looking at a case like this, what is ultravirus conduct truly when there is a large measure of discretion, whether it's absolute or not?
Your Honor, you know whether there's an ultra-virus violation in simply determining whether or not the commissioner acted in a manner that exceeded the authority given, whether it was a discretionary act or not. I think what Your Honor is getting at is how many of these violations do we need to prove in order to establish an ultra-virus claim? Just one, Your Honor. First of all, the trial court said in her order that these lists of violations were singly and collectively enough to grant the relief in question. But, Your Honor, there is no causation requirement for an ultra-virus claim. We are simply seeking prospective relief. We are not asking for damages. We're not seeking to be awarded a contract. We're not asking to undo the procurement. All we're asking for is the unlawful conduct to stop. That is what an ultra-virus claim, and that's the relief that we're asking for in this case.
So how does that going to play out? We start the bidding process over again?
Your Honor, it's up to the commissioner what she does from here, but
What are you're starting out by what you're asking for. What are you asking to start it over again, or to go back and document what they considered? What?
Your Honor, in our pleadings, all we're asking for is the prospective relief of stopping the unlawful conduct from occurring. Now, if the commissioner decides to redo the contract, the procurement down the road, yes, we would certainly be amenable to that. We can't dispute that.
How long does that usually take?
Your Honor, I can't remember the exact timing here, but I think the procurement lasted maybe 9 months to a year, but I may be wrong on that. I'm happy to give you an answer after the argument.
Thank you.
So, Your Honors, I want to go back to a question that Justice Ferris asked, and that is the relevance of Title I, Section 391.309 of the Texas Administrative Code, which states that the commissioner is not required to actually decide a bid protest appeal before moving forward with awarding the contracts. And that's important on one of the central issues and arguments that the commissioner has raised in this case, and that goes to exhaustion. The commissioner and Molina argue ad nauseum that we were supposed to wait until the commissioner decided the bid protest appeals before we could file our ultra vires action. And 391.309 stands for the proposition that if the commissioner wasn't even required herself to decide these bid protest appeals, then it logically follows that we were not required to wait for her to take an action that she might not take. And as a purely practical matter, Your Honor, the reason why there was urgency here and why we had to act is because there was testimony by the commissioner herself during the evidentiary hearing that once she decided the bid protest appeals, she could immediately sign and execute the contracts in question. At that point, after she did that, there is an argument that any relief that we asked for at that point to undo those contracts or whatever would be retrospective, and that would defeat our ultra vires claim. That is a theme of the commissioner's argument throughout the briefs that they filed, which is they are attempting to put us in a box, in a catch-22 situation where if we don't file our suit before the specification protest before the bid proposals were submitted, well then it's premature. But if we wait until after the bid protest appeal is actually decided, then it's too late. Your claims are arguably moot or they're retrospective. And so we acted when we acted, and it's in accordance with Texas law as well, and that's perhaps the most important point that I should have led with, and that is there simply is no requirement that ultra vires claims must satisfy the exhaustion requirement. We cited a number of cases on page 38 of at least the children's plans briefs where courts have repeatedly held that ultra vires claims are an exception to the exhaustion requirement, and indeed in many of the cases that Molina cites and the commissioner cites, the courts have held the same. But more importantly, there's a general proposition of law supported by the Supreme Court that when you're asserting a common law claim, unless there is a statutory exhaustion requirement, then there is no requirement. And here, there is no statutory exhaustion requirement saying that you can't file an ultra vires claim until you complete the bid protest appeal in this case.
I think the underlying concern here is just, and it's not, something that the parties have created, it's just the development of the case law. Ultra vires is just becoming so pervasive that we don't want to be, stepping in and, freezing everything all the time for people to kind of go around the administrative process for things that truly should be resolved through the administrative process. Is there some line that you would have us draw for why this would be a permissible use of ultra vires, but we're not going to be back here every time any new procurement comes up?
Your Honor, let's assume that, to answer your question, I'm not sure that there's a bright line we can draw because honestly, I think it depends on the evidence presented. And here we were presented with a situation where if we waited until the commissioner decided the bid protest appeals, we faced a situation where we had to file our ultra vires claim, otherwise face the inability to assert it once and for all. I think you just have to go back to basics, Your Honor, to put it bluntly. The requirements to establish an ultra vires claim, to be candid, are somewhat strict. You have to prove that the commissioner not just simply violated any kind of statute, but violated statute that is connected to the scope of their authority. We believe we've satisfied that requirement in this case, but we don't think that all bid protesters in the future will be able to. Thank you, Your Honor.
Thank you. Mr. Grossman, is that correct?
That's correct, Your Honor.
Proceed.
Good afternoon, Mr. Chief Justice, and may it please the court. I wanted to start by emphasizing what it is that we're here on and why that matters. We're here on a temporary injunction and the denial of the plea to the jurisdiction. And why that matters is because of the standard of review that's applicable there. We have 13 separate legal violations found by the trial court and 4 separate plaintiffs. For HHSC to prevail, it needs to demonstrate that not a single one of the 4 appellees demonstrated a likelihood of success on a single one of the 13 legal violations the trial court found. And Your Honor, I respectfully represent that's a burden they cannot possibly meet here.
So at the hearing, they point out that the complaining parties all scored much lower than the parties that were selected for this, for these programs. Did the temporary injunction cover whether there was something wrong with those scores other than the commissioner didn't consider this or that, or didn't document that they considered this or that?
Your Honor, I'll hit on 2 points there. One, I think the representation that the complaining plans all scored much lower simply isn't true. With respect to my client, Wellpoint, we were the 5th highest scored of the 18 bidders. We received awards in numerous contracts, or in numerous service areas. We're here because we want the commissioner to follow the law.
And you want a few more of the contracts.
We certainly would not object to receiving them. But I think circling back to your question, really the complaint here is not so much about the scoring. And when you look at the different statutes that we're here on, that's a helpful explanation of why. A lot of the statutes require that the commissioner shall give preference to various things. Respectfully, there is no discretion in those. She does not have the discretion to choose not to give preference at all. And what the trial court found was that on those preference statutes, that's exactly what she'd done. That there was no evidence HHSC could present suggesting that that preference had been given. That their own testimony was that there was nothing you could look at to see where that preference was given.
But isn't the nature of preference also a little bit discretionary? It's not like a must award, must win. It's a preference, and you know.
So certainly HHSC has discretion in what the preference they give looks like. They do not have discretion to choose not to give the preference at all. And that's what the evidence below suggested happened here. These contracts were awarded based on scores. The scores came from evaluators. HHSC's own testimony is that they never told the evaluators who were giving those scores that the preference existed or should be taken into consideration. There's no way that HHSC with a straight face can suggest that someone who did not know that the preference was supposed to exist in the first place gave the preference. And I did want to circle back to one question that you all asked earlier with respect to, did the commissioner admit that she did not consider past performance? Yes, she did. One of the things that you see in the record here.
You wouldn't be able to give me a cite for that.
I do not have the page site, although we can certainly provide that.
Send that in later.
We can send that in later.
Better
but,
for you to look at for it than for me.
Yep, but one of the things that's in the record is testimony that the commissioner gave to the legislature. And her testimony to the legislature was that HHSC did not consider past performance. She certainly tried to come back in the hearing and suggest that yes, she did. But at a minimum, her own conflicting testimony creates a fact issue, which is enough for this to move forward with what we're here on today. And along those same lines, the Supreme Court's case law on ultra-virus claims makes clear that where there's an evidentiary question, the weighing of the evidence is for the trial court. Houston Belt says that. As long as there is some evidence that she did not comply with these statutes, and as we just covered, that there is a great deal of evidence that she did not comply with those statutes, that's enough to defeat the plea to the jurisdiction. And it was enough for the trial court to find that there was a likelihood of success on the merits to sustain the temporary injunction. Circling back to one other thing that you heard from the appellant's counsel, that they suggest that the right time to bring this claim would have been before the bids went in. Wellpoint submitted a pre-bid protest on one issue. That they argued that the award of mandatory CHIP contracts would clearly violate the statutory scheme. The commissioner's response was that us filing it at that point was premature because we didn't know whether we were going to win or lose yet. And I think that's illustrative of the box that the commissioner's trying to put the plans in here. The commissioner's position is that any complaint a bidder may have as to whether she's following the law is premature right up until the moment that it's too late. that there is no sweet spot that the commissioner believes exists that we could actually bring these claims. And that's why we have to act now, because if we let her execute the contract, we're going to be faced with her arguing, well, now there's no relief you can get.
What do you make of the argument that really your only remedy here is to go take this up with the legislature and see if they'll give you a right to sue?
I don't think that that's supported by Texas law. There are a number of Supreme Court cases that are cited in Wellpoint's brief that say that a citizen or a litigant does not need the legislature's position to ask the state of Texas to follow the state of Texas's own laws. That's sort of the theory underlying the ultravirus claim. And I don't think there's any basis for the court to back away from that. I will agree with my co-counsel that there may not be a bright line that we can draw here, but I think there certainly is a line. We're not here quibbling about whether a timing requirement was complied with. We're dealing with statutes where the legislature has expressly said when the commissioner awards Medicaid contracts, she has to consider these things. Where the commissioner has decided, I don't want to consider these things.
Well, I'm looking, I mean, some of them say that, some of them don't. 0204 says you got a commission shall consider different plans to meet different populations, consider the ability of the organization to process Medicaid claims, and give extra consideration. I'm not sure what's the difference between consideration and extra consideration, but they say give extra consideration to continuity of care and all that stuff. Well, how in the world is that justiciable? All the respect in the world for the trial court, but the trial court cannot decide whether the record supports that or not. We defer to the agency for those kind of calls, generally speaking.
I think the one thing that the trial court can consider, and maybe this is the bright line we're here on, when there's no evidence that the commissioner did it at all, it's not difficult for the trial court to draw that conclusion. And that brings me back to my point that I began with, to prevail, we just have to show that we had a likelihood of success on any of those claims, and at least the ones that say that the commissioner shall give preference to. The question of did she or did she not follow that is not a hard one to resolve.
Thank you, Mr. Grossman. Ms. Walker.
Thank you, Mr. Chief Justice. May it please the court. Justice Ferris, I'd like to start by addressing your question about why won't we be back here on ultravirus claims on every procurement matter. We won't, because this is not a typical procurement matter. The managed care plans do not compete based on price. The state sets the price. That makes the other factors even more important. And here, this is different because the legislature has enacted statutory provisions that apply exclusively to Medicaid and CHIP contract awards. And those statutory provisions direct the commissioner to do certain things, including that she shall give preference to provider networks that are existing at the time, as well as to whether the plan has successfully implemented quality initiatives. And it does those because the legislature obviously considered those things important for the commissioner to do in awarding these critical contracts that will affect the lives of millions of Texans. And after 4 days before the trial court, what the evidence overwhelmingly shows is that the commissioner has noticed her intent to award Medicaid and CHIP contracts while disregarding those statutory mandates. And by the way, the legislature, when they recently reenacted those statutes and moved them within the statutory provisions, they left those mandates in there. They're still there. And so she is ignoring those. And just to give you a couple examples of the evidence below with regard to the preferences, the evidence shows that the evaluators were not told to look at existing provider networks. They were not told to apply a preference. They were not even told that a preference existed. So there's no way when the commissioner based her awards based on the scores the evaluators gave that there could be a preference.
So just going, I'm following the argument on that, but I guess taking it 2 steps further, then isn't the only way to fix that a new procurement, which is not what is being specifically pleaded for, or?
Well, Your Honor, what we're asking for, this is an ultravirus action for injunctive relief to stop the commissioner from doing something that's going to exceed her authority and conflict with law. We're asking that the court enjoin her from proceeding with the contract awards that she has noticed. She has said what she intends to do. So,
I hear you,
yes.
and you're doing the best you can with a strange statute, but what do we do, you know? I am reticent to be the court that says, great, we've disregarded getting a new procurement for 2 years, let's do it for another couple of years, go back, and this time have a checkbox where you check off all the things that was in the temporary injunction, and then is that all we're here for? That what you need is the commissioner needs to have a checkbox where she can check off all these things and then do whatever she wants, because she does have a lot of discretion here. She determines, and best value, you know, that may or may not fit with veterans' preferences or whatever. That's not particular here, but various other of these preferences. Is that all this is about?
No, Your Honor, this is about the commission.
Great health care, I know that, but actually it's not about great health care. You're not here telling us that you all are a better health care plan. You have not told us that in your brief. You didn't try to prove that, and it would be, I don't think courts would be any good at trying to decide that. You're telling us they didn't have the check boxes checked.
It's not just check boxes, Your Honor. It's statutory provisions. The legislature has put those statutes.
Sorry, statutory check boxes.
And I'm not sure the legislature, when they enacted those, would consider them check boxes. They put them there and they use the word shall.
So it's not like, it's not may, it's the shall word that,
Shall
I'm
consider.
focusing, no, not in the 533-003.
And one, and all the rest are shall consider, which a checkbox would show I considered it.
With regard to the preferences, and I want to focus on the preferences, again, any of the findings from the trial court support the court's order, but I'd like to focus on the preferences. In those statutes, and I'm referring to the statutory provisions that existed in the record at the time, I know they've been moved.
Right.
But 533-003 talks about when, it says when awarding a contract, the commissioner shall give preference. It doesn't say may, it doesn't say, so when she is awarding a contract, and not just any contract, a Medicaid contract for 533-003, she is required to give a preference.
But again, we're going around in a circle here. I'll give you some time back, but this is where I'm caught in a circle. Then if I press you on that, everybody would agree, you know, a veteran's preference or, you know, this, that, you know, economic disadvantage preference. Doesn't mean all the veterans or economically disadvantaged people get into UT Law School. It's something that if everything else is exactly equal, then we do the preference. That's really what a preference is. But then whenever I say that, well, it's just, they have to be exactly equal. You say, oh yeah, but there's no evidence she considered it, and we're back to check boxes.
Well, Your Honor, no, I'm not saying there's no evidence she considered it. She did not consider it, but there's no evidence she gave the preference. And the preference here just says she has to give the preference. It doesn't say when all things are considered equal. The legislature has done that in other statutes, and it is cited in the briefing of the commissioner. 2155-444 is an example where the legislature said when all other things, price and quality, are considered equal, you have to give a preference. That's not what the legislature said here in 533-003.
Does this any of the preferences you mentioned override best value?
No, they don't override, but she has to give a preference. If she had given a preference, we wouldn't be here. A couple reasons why we know she didn't give a preference. Melina got the highest score in the quality question that Mr. Scanlon referenced. There's evidence in the record, it's Exhibit 69, where HHSC says Melina gets the lowest quality scorecards, scores of any plan in all but one of the regions it operates, and it doesn't meet minimum performance standards in any of the areas where it operates. It got the highest score in quality. They did not apply a preference. With regard to the provider network preference, there's evidence in the record, and it's Exhibit 283 of the plaintiff's exhibits, that shows that Blue Cross Blue Shield got the highest score on what they claim is the provider best value criteria, and they were awarded a contract in Hidalgo County. There's evidence in 283 that shows they have 0 hospitals in their network at the time of that contract award in Hidalgo County, and they have 0 federally qualified health centers. They could not possibly have met the preference requirement in 533-003. but yet they got the higher score. There was no preference given. The evidence is overwhelming below.
You can take another couple of minutes because I took up so much of your time.
Sure. So the court should reject the commissioner's argument that she can ignore what the legislature has said she must do. And it should also reject the commissioner's argument that basically no court can review her action. The reason we have ultra-virus actions, it's a safety valve to make sure that a public official complies with the law. When you have a public official that's ignoring the law, that's a problem. That's why we're here.
So address, if you would, the last exchange I had with Mr. LaFond of where they want to say there's no ultra-virus because there's exclusive jurisdiction. Could you go ahead and address whether there's exclusive jurisdiction in the commissioner here?
There is not exclusive jurisdiction. In the Aspire case is very different than this case, simply because the legislature has given the commissioner authority to adopt procurement rules in a protest procedure doesn't mean there's a pervasive regulatory scheme. So there is not exclusive jurisdiction here. And there is case law saying that where there is an ultra-virus action, that you don't have to exhaust administrative remedies. And that's why we're here. And we would ask that you affirm the court. The trial court correctly denied the plea to the jurisdiction and did not abuse its discretion in entering the temporary injunction.
Thank you, Ms.
Thank you.
Walker. Mr. Scanlon? Has somebody told the commissioner next time she needs to check the check boxes?
I think
I
that.
said maybe attorney-client privilege, but for crying out loud, did they check the check boxes that the statute said they needed to check?
The check boxes were checked, Your Honor. The RFP incorporated every one of those statutory provisions. They were set out in the best value criteria. The bidders had an opportunity to explain, and I believe it was 7 to 10 pages in their proposal, how they would qualify for a preference. And then the evaluators, who were trained on those best value criteria, took their presentations and scored them and decided who was going to win the award. That is a matter completely within the commissioner's discretion
But
to choose a winner.
can we match up the statutory requirements and preferences and shall considers to the score sheets?
Yes, you can. You can match
Is that in your brief somewhere, or?
It is explained at length in the brief. This is a bit of a technical requirement. Today, I would highlight the 536052 preferences on quality initiatives, where I think I quoted technical question 13 to you earlier, how it talks about quality improvement, performance evaluation strategies. The language substantively gives the effect to all of these statutes. We've explained that at length in our brief.
Could I ask you a question just on the nature of ultravirus? And I know you'll tell me this is not this case, but if, hypothetically speaking, you had shall consider, shall document, that undisputed testimony absolutely did not happen, still no ultravirus in that scenario?
So in that scenario, if you have an official where they have completely disregarded the statutory requirements, that would be remedied through the protest process. You would have an RFP that sets out the rules. You'd have a conduct where that's not been applied. And, if the commissioner was going off the rails, there are oversight, internal checks to that. That would be the remedy.
Yeah, but let's just say, taking her question and going further, let's just say that we're not buying the exclusive jurisdiction argument. So you get a ultra-virus claim. Now answer the question.
So if you're not going to find that there's exclusive jurisdiction, the court should still find that the claim's not ripe because the protest process wasn't followed. Ultra-virus requires them to show that we exceeded the statutory authority, right?
But what I'm hearing is, whatever you do, don't decide ultra-virus because we have all these other reasons.
That's the case that they've brought. They've asserted that they are trying to enjoin the contracting process.
No, what she's asking, I think, I hate to say what you're asking, but you tell me if I'm wrong, is that ultra-virus conduct? And you're saying, well, it's not ripe. Well, I'm saying, well, assume it's ripe.
Assuming it's ripe, it would still be retrospective under the facts of this case. And I understand,
I'm not asking if there's a remedy. I'm asking, is it ultra-virus conduct?
It's always ultra-virus conduct if they're not following the statute,
Which
but
is
you have to
answer to
meet
your
all,
question.
all the requirements of that. Chief Justice Brister, you asked how long the procurement was undergoing. This process started in 2019. It's been many years that this procurement has been going on, and the trial court undid that in 4 days. The legislature also had a chance to address how this would be remedied. They made no changes to the statute. This case was abated so that the legislature could decide whether there was going to be a fix here, and it took no action on these statutes other than, you know, the non-substantive recodification. So the legislature's shown what the remedy's supposed to be here. The fact that they haven't pled a viable ultra-virus claim shouldn't, I think another point that needs to be made, though, is that if we accept their position that you can sue without exhausting the protest process, you are going to see many incumbent bidders especially suing the agency as soon as they get a whiff that they're going to lose a contract. And that clearly is not the result that the legislature intended. They made the point about, we talked, I think, too long about past performance. Again, it's a may consider factor, and I would also give cites to James Ramirez's testimony, volume 5 of the report of records, page 227, where he said that if you are asking me whether it's relevant, you have to look at what it says in the RFP. The RFP is the driver of what's a relevant consideration. And if they had a problem with how it was going to be implemented, they were obligated to protest the RFP. None of the protests in the RFP said anything about that. The only one that was made that's arguably before the court today is Wellpoint's protest about bundling CHIP and STAR. And that's just unmeritorious on the face of the statute that applies, which says the commissioner may prefer MCOs that provide similar coverage under Medicaid in awarding CHIP. And again, that's just a flagrant incorrect statement in the TI. So there are plenty of grounds for reversal, but we think that you shouldn't have to look at all of the evidence from the hearing. If you look at the pleadings and read these statutes on their face, they provide the discretion to do what they're alleging that the commissioner has done. So if you do reach the evidence, none of it creates a fact issue. None of it creates an issue that says that the commissioner exceeded her statutory authority or used her discretion to exceed her statutory authority. What happened at the hearing was just an improper exercise in burden shifting. They would get agency witnesses on the stand. They would have them concede that the statutory factors weren't applied in the exact way that they demanded, and therefore that was somehow an ultra-virus claim. Again, they haven't brought you anything to show that the statute was violated here and can be enjoined as ultra-virus in the first instance. I think with that, I would yield my time.
Thank you very much. Thank you, ladies and gentlemen. The case will be submitted. We'll take a 10-minute break, and then we'll be back for the next case.
All rise.